Dear learners, welcome to this session. Today we will be discussing about the protocol to prevent, suppress and punish trafficking in persons, especially women and children, and human trafficking in India. So we have seen that this protocol defines human trafficking, Article 3. Now we will be discussing about this protocol and we will see the linkages between human trafficking and this protocol in this session. The preamble of this protocol says the state parties to this protocol declaring that effective action to prevent and combat trafficking in persons, especially women and children, requires a comprehensive international approach in the countries of origin, transit and destination that includes measures to prevent such trafficking, to punish the traffickers and to protect the victims of such trafficking, including by protecting their internationally recognized human rights. So, as this issue of human trafficking is a global issue, similarly the protocol addresses it globally. So, you have a comprehensive international approach to handle the origin, transit and destination, and to have preventive measures for trafficking, to punish the traffickers and to protect the victims and survivors of trafficking. And protecting their human rights. We say that human trafficking is the worst form of abuse of a person's human right. So, here we have this preamble. Taking into account the fact that despite the existence of a variety of international instruments containing rules and practical measures to combat the exploitation of persons, especially women and children, there is no universal instrument that addresses all aspects of trafficking in persons. So, it is very true that we do not have an international document which caters to every issue of human trafficking globally. Concerned that in the absence of such an instrument, persons who are vulnerable to trafficking will not be sufficiently protected. So, even in the protocol this has been accepted that in want of any international instrument, the vulnerable people will not be sufficiently protected. Recalling General Assembly Resolution 53-111 of 9 December 1998, in which the Assembly decided to establish an open-ended intergovernmental ad hoc committee for the purpose of elaborating a comprehensive international convention against transnational organized crime and of discussing the elaboration of inter alia an international instrument addressing trafficking in women and children. Convinced that supplementing the United Nations Convention against transnational organized crime with an international instrument for the prevention, suppression and punishment of trafficking in. Article 1 talks about relation with the United Nations Convention against transnational organized crime. This protocol supplements the United Nations Convention against transnational organized crime. It shall be interpreted together with the convention. Very true, so we have discussed the convention first and now we are talking about the protocol. The provisions of the convention shall apply mutatis mutandis to this protocol unless otherwise provided herein. The offences established in accordance with Article 5 of this protocol shall be regarded as offences established in accordance with the convention. Article 2 talks about the statement of purpose. The purpose of this protocol are to prevent and combat trafficking in persons, paying particular attention to women and children, to protect and assist the victims of such trafficking with full respect for their human rights. And this is why we say that we have protection of human rights in India, we have constitution in India, we have different legislations in India, and then this protocol. But still, do you think that the victims of trafficking are respected? Their dignity rights are being protected? No. So we say that these people are trafficked, these people are vulnerable, these people are not accused of a crime but a victim of a crime. To promote cooperation among state parties in order to meet those objectives. Article 3 talks about the definition of trafficking in persons, which we have already discussed in one of the sessions, wherein we talked about defining human trafficking. Again, you can see a recall. Trafficking in persons shall mean the recruitment, transportation, transfer, harboring, or receipt of persons. This is totally valid. You can recruit a person, you can transport a person, you can transfer a person, you can harbor a person, or you can receive people. But means are very important. Means make it a criminal offense. Means of threat or use of force or other forms of coercion, of abduction, of fraud, of deception, or the abuse of power or of a position of vulnerability, or giving or receiving the payments or benefits to achieve the consent of a person, having control over another person. So this is very important. We talk that people who are in slave trade, people who are working as laborers, people who are working as sex workers give their consent. But is this consent a valid consent under the Indian Contract Act? No, because the consent is not a free consent if that has been taken from coercion, from abduction, by fraud, by threatening the person, by using force on that person, by abusing your control or power over that person, by paying somebody who is controlling that person. And the purpose of this recruitment, transportation, transfer, harbor, or receiving a person is exploitation. So the purpose is not legal. The purpose is illegal, that is exploitation. Exploitation shall include at a minimum the exploitation of the prostitution of others or other forms of sexual exploitation, forced labor or services, slavery or practices similar to slavery, servitude or the removal of organs. So how can I agree to somebody to remove my organ when I know that after the removal of organ I will die? Can slavery be allowed? Can labor trafficking be allowed? Can bonded labor be allowed? Can pornography and sex trade, mail order brides, false marriages, any kind of trauma, any kind of violence be allowed by a person? Can a person give consent for all these things? If the consent has been obtained by force, by fraud, by deception, by abduction, by coercion, then am I not vulnerable to my situations and should get the benefit of being a victim or a survivor of human trafficking? my ignorance, my illiteracy, my unemployment can be a reason for trafficking. So, if the laws are not implemented properly, if the public distribution system does not happen properly in my country, if I do not have quality education, if I do not have access to the resources, access to the infrastructure, then there are so many issues related to my dignity and worth. So, in these cases, I should get the benefit of being considered as a victim of trafficking and not an accused or a person, who should be convicted by the court of law. The consent of a victim of trafficking in person to the intended exploitation set forth in subparagraph A of this article shall be irrelevant where any of the means set forth in subpara A has been used. So, consent is immaterial. The recruitment, transportation, transfer, harboring or receipt of a child for the purpose of exploitation shall be considered trafficking in persons even if this does not involve any of the means set forth in subparagraph A of this article. Child shall mean any person under 18 years of age, a global definition of child. Article 4 talks about the scope of application. This protocol shall apply except as otherwise stated herein to the prevention, investigation and prosecution of the offences established in accordance with Article 5 of this protocol, where those offences are transnational in nature and involve an organized criminal group, as well as the protection of victims of such offences. Article 5 talks about criminalization. Each state party shall adopt such legislative and other measures as may be necessary to establish as criminal offences the conduct set forth in Article 3 of this protocol when committed intentionally. Each state party shall also adopt such legislative and other measures as may be necessary to establish as criminal offences. And that is why we need a stringent law on human trafficking. Yes, we have defined human trafficking under IPC. Yes, we have Immoral Trafficking Prevention Act. We have a bill pending and we hope that this bill addresses the issues of human trafficking while taking into consideration the inputs from the stakeholders and from the victims of trafficking. Participating as an accomplice in an offence established in accordance with paragraph 1 of this article, subject to the basic concepts of its legal system, attempting to commit an offence established in accordance with paragraph 1 of this article, organizing or directing other persons to commit an offence established in accordance with paragraph 1 of this article. Protection of victims of trafficking in person is given in chapter 2. Article 6 talks about assistance to and protection of victims of trafficking in persons. In appropriate case and to the extent possible under its domestic law, each state party shall protect the privacy and identity of the victims of trafficking in persons, including inter alia, by making legal proceedings related to such trafficking confidential. So, we have in-camera trials for human trafficking cases. We have fast-track courts to dispose of the cases of human trafficking. We just need a proper mindset, training and a sensitive attitudes towards addressing the issues of human trafficking, and each party shall ensure that its domestic legal or administrative system contains measures that provide to victims of trafficking in persons in appropriate cases information on relevant court and administrative proceedings. This is very important for a person, who is vulnerable. He will not understand the way the court functions. assistance to enable their views and concerns to be presented and considered at appropriate stage of criminal proceedings against offenders in a manner not prejudicial to the rights of the defense. This is very important. You have to be heard. You must remember that we have discussed the principles. In the principles, we have also discussed that the person or the victim should be heard, and here is the article also. Each state party shall consider implementing measures to provide for the physical, psychological and social recovery of victims of trafficking in persons, including in appropriate cases in cooperation with non-governmental organizations, other relevant organizations and other elements of civil society, and in particular the provisions of appropriate housing, counseling and information, in particular as regards to their legal rights, in a language that the victim of trafficking in persons can understand. This is very important. If you talk to me in English and I don't understand English, or in Tamil or in other languages which I don't understand, then I cannot become a party to that case. So it is very important that I should understand the proceedings, and this is why we have translators. Medical, psychological and material assistance can be provided to a person who has been trafficked, and employment, educational and training opportunities for the people who have been trafficked. Each state party shall take into account in applying the provisions of this article the age, gender and special needs of victims of trafficking in persons, in particular the special needs of children, including appropriate housing, education and care. And this is why we have discussed so many legislations. We have discussed the Juvenile Justice Act, then we have discussed Indian Penal Code, then Immoral Traffic Prevention Act. So all these legislations are there. The Constitution of India is there to protect the rights of the victims. Each state party shall endeavor to provide for the physical safety of victims of trafficking in persons while they are within its territory. Each state party shall ensure that its domestic legal system contains measures that offer victims of trafficking in persons the possibility of obtaining compensation for damage suffered. This is a very important provision. Article 7 talks about status of victims of trafficking in persons in receiving states. In addition to taking measures pursuant to Article 6 of this protocol, each state party shall consider adopting legislative or other appropriate measures that permit victims of trafficking in persons to remain in its territory, temporarily or permanently in appropriate cases. In implementing the provisions contained in paragraph 1 of this article, each state party shall give appropriate consideration to humanitarian and compassionate factors. Article 8 talks about repatriation of victims of trafficking in persons. The state party of which a victim of trafficking in person is a national, or in which the person had the right of permanent residence at the time of entry into the territory of the receiving state party, shall facilitate and accept with due regard for the safety of that person the return of that person without undue or unreasonable delay. A very important article. When a state party returns a victim of trafficking in persons to a state party of which that person is a national, or in which he or she had at the time of entry into the territory of the receiving state party the right of permanent residence, such return shall be with due regard for the safety of that person and for the status of any legal proceedings related to the fact that the person is a victim of trafficking, and shall preferably be voluntary. At the request of a receiving state party, a requested state party shall without undue or unreasonable delay verify whether a person who is a victim of trafficking in person is its national or had the right of permanent residence in its territory at the time of entry into the territory of the receiving state party. A very important provision when you talk about, the right of people who go without valid visa and passports. In order to facilitate the return of a victim of trafficking in person who is without proper documentation, the state party of which that person is a national or in which he or she had the right of permanent residence at the time of entry into the territory of the receiving state, party shall agree to issue at the request of the receiving state party such travel documents or other authorization as may be necessary to enable the person to travel and to re-enter its territory. This article shall be without prejudice to any right afforded to victims of trafficking in person by any domestic law of the receiving state party. This article shall be without prejudice to any applicable bilateral or multilateral agreement or arrangement between governments in whole or in part the return of the victims of trafficking in persons. Chapter 3 talks about prevention, cooperation and other measures. Article 9 talks about prevention of trafficking in persons. State party shall establish comprehensive policies, program and other measures to prevent and combat trafficking in persons, to protect victims of trafficking in persons, especially women and children, from re-victimization, from re-trafficking, State parties shall endeavor to undertake measures such as research, information and mass media campaign and social and economic initiatives to prevent and combat trafficking in persons. Policies, programs and other measures established in accordance with this article shall, as appropriate, include cooperation with non-governmental organizations, other relevant organizations and other elements of civil society. State parties shall take or strengthen measures including through bilateral or multilateral cooperation to elevate the factors that make persons, especially women and children, vulnerable to trafficking such as poverty, underdevelopment and lack of equal opportunity. A very important article. State parties shall adopt or strengthen legislative or other measures such as educational, social or cultural measures including through bilateral or multilateral cooperation to discourage the demand that foster all forms of exploitation of persons, especially women and children, that leads to trafficking. Another very important article. Article 10 talks about information exchange and training. Law enforcement, immigration or other relevant authorities of state parties shall, as appropriate, cooperate with one another by exchanging information in accordance with their domestic laws to enable them to determine whether individuals crossing or attempting to cross an international border with travel documents belonging to other persons or without travel documents are perpetrators or victims of trafficking in persons. The type of travel document that individuals have used or attempted to use to cross an international border for the purpose of trafficking in person. Article 10 is very important to check cross-border trafficking. The means and methods used by organized criminal groups for the purpose of trafficking in persons, including the recruitment and transportation of victims, routes and links between and among individuals and groups engaged in such trafficking and possible measures for detecting them. State parties shall provide or strengthen training for law enforcement, immigration and other relevant officials in the prevention of trafficking in persons. The training should focus on methods used in preventing such trafficking, prosecuting the traffickers and protecting the rights of the victims, including protecting the victims from the traffickers. The training should also take into account the need to consider human rights of the child and gender sensitive issues, and it should encourage cooperation with non-governmental organizations, other relevant organizations and other elements of civil society. A state party that receives information shall comply with any request by the state party that transmitted the information that places restriction on its use, a very important provision. Article 11 talks about border measures. Without prejudice to international commitments in relation to the free movement of people, state parties shall strengthen to the extent possible such border controls as may be necessary to prevent and detect trafficking in persons. Each state party shall adopt legislative or other appropriate measures to prevent, to the extent possible, means of transport operated by commercial carriers for being used in commission of offences established in accordance with Article 5 of this protocol. Where appropriate and without prejudice to applicable international conventions, such measures shall include establishing the obligation of commercial carriers, including any transportation company or the owner or operator of any means of transport, to ascertain that all passengers are in possession of the travel documents required for entry into the receiving state. We can check border crimes, border trafficking, if we follow this article. Each state party shall take the necessary measures in accordance with its domestic law to provide for sanctions in case of violation of the obligations set forth in para 3 of this article. Each state party shall consider taking measures that permit, in accordance with its domestic law, the denial of entry or revocation of visas of persons implicated in the commission of offences established in accordance with this protocol. Without prejudice to Article 27 of the Convention, state parties shall consider strengthening cooperation among border control agencies by inter alia establishing and maintaining direct channel of communication. This is very important, Article 12 talks about security and control of documents. Every state party shall take such measures as may be necessary within available means to ensure that travel or identity documents issued by it are of such quality that they cannot easily be misused and cannot readily be falsified or unlawfully altered, replicated or issued, and to ensure the integrity and security of travel or identity document issued by or on behalf of the state party, and to prevent their unlawful creation, issuance and use. Article 13 talks about legitimacy and validity of documents. At the request of another state party, a state party shall, in accordance with its domestic law, verify within a reasonable time the legitimacy and validity of travel or identity documents issued or purported to have been issued in its name and suspected of being used for trafficking in persons. Article 14 is a saving clause which says nothing in this protocol shall affect the rights, obligations and responsibilities of states and individuals under international law, including international humanitarian law and international human rights law, and in particular where applicable the 1951 Convention and 1967 Protocol relating to the status of refugees and the principle of non-refoulement as contained therein. The measures set forth in this protocol shall be interpreted and applied in a way that is not discriminatory to persons on the ground that they are victims of trafficking in persons. The interpretation and application of those measures shall be consistent with internationally recognized principle of non-discrimination. So, you cannot discriminate. If there is a dispute, then Article 15 talks about settlement of disputes. State parties shall endeavour to settle disputes concerning the interpretation or application of this protocol through negotiation. Any dispute between two or more state parties concerning the interpretation or application of this protocol cannot be settled through negotiation within a reasonable time shall, at the request of one of those state parties, be submitted to arbitration. If 6 months after the date of the request of the arbitration, those state parties are unable to agree on the organization of the arbitration, any one of those state parties may refer the dispute to International Court of Justice by request in accordance with the statute of the court. And now we have International Criminal Court. Each state party may at the time of signature, ratification, acceptance or approval or accession to this protocol declare that it does not consider itself bound by paragraph 2 of this article. The other state party shall not be bound by paragraph 2 of this article with respect to any state party that has made such a reservation. Any state party that has made a reservation in accordance with paragraph 3 of this article may at the time withdraw the reservation by notification to the Secretary General of the United Nations. Article 17 talks about the protocol entered into force on 25th December 2003, which we have already discussed. In the end, I would just like to say that this is a protocol to punish, suppress trafficking, but we need awareness about this protocol. The definition given in Article 3 is very elaborated. So, we have this definition, but somehow we are not able to implement the laws and conventions and protocols related to human trafficking effectively in the countries. So, we have the Crime Records Bureau data which shows that human trafficking cases are increasing every day. So, we have to be aware about these protocols, conventions, and then we have to act diligently and reasonably. And in the end, I will say that protect your human rights and do not violate others' human rights. Thank you all for listening. Have a nice day.